Good afternoon. My name is Carolyn Jackson. I'm with the American Civil Liberties Union of Minnesota, and this is Howard Bass, who's also with the ACLU, and we're going to work as a team here. The American Civil Liberties Union of Minnesota is the Minnesota branch of the American Civil Liberties Union. We have over 10,000 members statewide. We protect the Constitution of the United States and the Constitution of Minnesota, focusing primarily on the civil liberties protected by the Bill of Rights. This is going to be an overview of constitutional law. I provided you with copies of the 4th, 5th, 6th, and 8th Amendments to the Constitution and the corresponding sections of the Minnesota Constitution. These sections are relevant to civil asset forfeiture. Civil asset forfeiture begins with law enforcement seizing property, and then it goes forward to forfeiture, which is the keeping of the property. The 4th Amendment protects individuals against unreasonable seizures. What constitutes a reasonable seizure varies depending on the underlying factual situation. The preference under the 4th Amendment is that law enforcement first obtain a warrant by showing a judge that there is probable cause to believe the item to be seized is evidence of a crime. Then the property is seized according to the terms of the warrant. However, warrantless seizures have been found to be reasonable under limited circumstances. In criminal cases, the burden is on law enforcement to show that a seizure complies with the 4th Amendment. If law enforcement cannot show the property was legally seized, it generally cannot be used as evidence and must be released to the owner. However, in administrative forfeiture, this burden is shifted. Under administrative forfeiture, when the property is seized, its title vests immediately with law enforcement. It is then up to the property owner to file a challenge, and we saw the complications involved with that.
Don't do that.
The property owner can claim the property was improperly seized or that it is not subject to forfeiture. However, the claim must be made within a limited time frame and according to specific rules. Making a claim also means the property owner will incur costs and attorney fees. With administrative forfeiture, if the owner does not properly challenge the forfeiture, law enforcement automatically gets to keep the property. Furthermore, if a property owner does file a claim, he waives his 5th Amendment protection against self-incrimination. An action for forfeiture is a civil action, and the property owner becomes subject to discovery. He can be deposed, and in being deposed must answer questions to get his property returned. The testimony in the forfeiture case can then be used against him in any underlying criminal case, automatically waiving his 5th Amendment protection against self-incrimination. The Institute for Justice will talk about due process and property under the 5th Amendment. Because administrative forfeiture is a civil matter, the property owner does not get the protections given a person accused of a crime. So one of the things I was looking at is when you have a forfeiture under a designated offense, one of those designated offenses is possession of child pornography. So property that's seized under a drug bust, the person who possessed the drugs has less protection than someone when they seize child pornography. So compare the two different defendants, as it were. The protection level's radically different. In a criminal trial, the state must prosecute. The presumption of innocence means that the state must prove that a crime was committed and that the accused who was the person who committed the crime. The standard of proof is guilty beyond a reasonable doubt, which is the highest standard of proof recognized in the American legal system. If the state does not make its case, the accused goes free. Contrast that with administrative forfeiture, where the state gets to keep the property unless challenged, and upon challenge must only show that the property is subject to forfeiture by clear and convincing evidence. In a criminal trial, the accused has 6th Amendment rights. The 6th Amendment says that the trial must be before a jury unless the accused waives the jury. The accused has a right to an attorney, and if they cannot afford one, they get a public defender. The state must inform the accused of the charges against him. The accused gets to see and cross-examine people, and he can force friendly witnesses to testify on his behalf. None of these protections apply to the property owner in a civil asset forfeiture case. Ironically, in administrative forfeiture, someone who may not have done anything wrong has fewer rights than someone indicted on felony charges. The Supreme Court has held that civil asset forfeiture is a punishment and as such is subject to the 8th Amendment. The amount of property seized must bear some proportionality to the severity of the offense that it is intended to punish. In asking whether a forfeiture represents an excessive fine, the first question is, who decides whether the forfeiture is excessive? The law enforcement officer who seized the property or a judge? In administrative forfeiture, the law enforcement officer makes that decision unless the property owner pays to challenge the forfeiture in court. Once the case is before a judge, then the question becomes whether the value of the asset seized is proportional to the severity of the underlying offense. The Bill of Rights represents a balance of power. Individual rights we keep balance against powers that we grant to law enforcement. Unchecked power opens the door for abuse. On behalf of the ACLU, I urge you to consider protections against abuse written into the law and the roles that protections should play in civil asset forfeiture. And Howard.
Thank you. Please go ahead, state your name for the record.
Madam Chair, remaining members of the committee, my name is Howard Bass. I will be brief in my remarks for several reasons. First of all, this has been a long hearing. The 3-hour maximum parking that I paid for has just expired. And it's been a complicated and unnecessarily complicated subject matter that our statutes have created. I was asked to discuss the civil liberty ramifications of forfeiture, specifically administrative forfeiture, and particularly with respect to drug forfeitures, associated property. And I will do so. One of the benefits of testifying late in the day like this is I've had the opportunity to listen to the testimony and the questions that have been asked, and I can answer some of the questions that went unanswered for you. I'm a criminal defense attorney. I'm a board member for the ACLU Minnesota. I'm a volunteer ACLU Minnesota attorney. I was previously president of the Minnesota Association of Criminal Defense Lawyers. So this is what I do. There are two principal civil liberties concerns that are raised, at least in my view, by administrative forfeiture. The first is illustrated graphically by the problem with the Metro Gang Strike Task Force. The statutory scheme simply puts too much authority and too much discretion into the hands of law enforcement officers. Most of these seizures that result in administrative forfeiture are warrantless seizures. They are presumptively, under both our federal and state constitution, unreasonable. There are exceptions, but they are presumptively unreasonable. There is no neutral and detached judicial officer who reviews these seizures, either prior to the time that the police seize the property by issuing a warrant, or after the property is seized through a judicial determination of forfeiture, unless the party whose property is seized files the demand for judicial determination of forfeiture. So there's no check and balance. And you need to remember that our constitutional system establishes checks and balances between various branches of the government. And one of the principal checks on abuses by the executive branch, which includes law enforcement, police officers, is the courts, the judicial branch. So you don't have a check and balance by a judge, a neutral, detached judicial officer issuing a warrant prior to the seizure, nor at the time that the property is deemed forfeited. This creates a potential for abuse. Despite testimony that you've heard today about how prosecutors will review all administrative forfeitures, how that form, one of the copies, is sent to the county attorney's office at the time that the law enforcement agency makes the seizure and initiates the administrative forfeiture process, there's still no check and balance in a constitutional sense, because the prosecutor, the county attorney, just like the police officer, are members of the executive branch. And under our separation of powers, it's one branch, it's one hand, there's no check on it. Consequently, there is a significant potential, and I would argue a likelihood, for the potential that owners will be deprived of their property without due process of law. You've heard Mr. Plunkett testify about the cost-benefit analysis. A lot of people will not and cannot afford to pay the filing fees or to hire the attorney to contest forfeiture. And like Mr. Plunkett, I've had people contact me over the years who want to contest a forfeiture, and I say my fees are going to vastly exceed the value of this property.